I generally don't mind if review hearings are listened to, and I don't, but it's very obvious that a review hearing, and review hearings tell the public what is going on. Closing review hearings generally protects, I believe, agencies more than people. All right, this is in the matter, we have them all in the matter of, for those that you don't know, there is a request was made by the media to photograph the proceedings. They are present. Apparently they're photographing the proceedings.
I know I would like to be heard on that matter, if I may.
All right.
This is Candice Saip, District Attorney's Office.
Okay.
That order was submitted, I believe, ex parte to the court. Was not served with a copy of it, so I was not aware until last night that this was going on. I am concerned that according to their website, it looks like this hearing, the recording is going to be posted to their website and available for public viewing. Not only does this concern the abuse and neglect of the minor in this case, but also another child, and that the children's identities are confidential by nature.
What do you intend to do with this?
This is connected to our coverage in Department 15. There's already proceedings in Department 15 that have certain things that are public.
So she's right, you intend to take this and put it on the internet?
Right, but we do redact the names of the parties. We've already published footage of child custody coverage. It's already out there. This isn't the first time ever. And then with regards to the ex parte process, that's established by the Supreme Court rules. We don't have any control over that. We have to abide by Supreme Court Rule 230 to get this to happen. This is very standard in non-family division cases, but I guess this is new to her and she's not aware as to how it works. We file a request, the court enters the order. If somebody has an issue with it, then they file an objection. But this is something we've been doing for a while. The only thing that we're doing that's new is this is our first NRS 432B proceeding. That's the only thing that's new here.
Well, it's a big difference.
I understand. So we reviewed the
Right,
statute.
that is the problem, is that it's a dependency proceeding.
At this point, I'm just going to jump in because before we set up, there was an important portion of an exchange between the judge and Brittany about not bringing the camera in, and it gives a lot of context to what is about to go on here. As Brittany took the camera in, the judge was upset and tried to stop her. He was even more upset when he found out District Court Judge David Gibson had granted our request to provide electronic coverage. The first thing I'd like to mention is that these proceedings are automatically more public than the proceedings we covered before District Court Judge Tamitha Schreiner, who, if you can recall, did her homework.
The Arnavetta Judges is a site that just essentially opens the courts to members of the public if they so wish, looks at judges' appeals, ratings, etc. For the domestic type cases such as this, any names of parties and children's names would be redacted. Thoughts from counsel?
No objection. It's a public hearing.
Well, I'm not. I think it's weird to consider it a public hearing because every time I go to family court, the doors are shut and so the parties involved.
Well, Mr. Davies, let me just, I'm sorry to interrupt you, but I did do a bit of research just to confirm this weekend. A custody matter does not have an ability to be sealed. Divorce cases do, and paternity cases are sealed by law. So it is a public hearing. And so actually, I know Mr. Falcone does not have to redact names of children and parties, but that is, they understand the sensitive nature.
The reason why is the legislature enacted a statute. I would imagine that this is in place because unlike child custody proceedings, which are a dispute between two parents, abuse and neglect proceedings involve multiple government agencies, including CPS, Child Protective Services, a part of the Department of Family Services, and the District Attorney's Office. So the law basically appears to favor transparency with some exceptions. The government is not used to this kind of scrutiny, at least CPS isn't, and I understand that they push the argument that they need to keep things secret to protect the children, but the problem is that they are under serious scrutiny already for their inability to protect children, as evidenced by the Las Vegas Review-Journal's investigation into CPS for all of the children that have died in their care. That's right, CPS and the District Attorney's Office is not just picking on us, they appear to do this to everyone, including the Las Vegas Review-Journal, which is the biggest newspaper in the state. In that case, District Court Judge Jim Crockett had to order them on multiple occasions to turn over child autopsy reports. And they use the same arguments against the Review-Journal that they're trying to use now against us as well. We're fortunate at least that we were able to record this portion of the hearing because it also exposes some of the tactics that we have to get through to actually bring media coverage to the public. The district attorney, for example, characterized the request as ex parte, but they know how this process works. The district attorney's office has seen probably hundreds of thousands of media requests. When it comes to the defense attorney, he does the same thing in a different way.
No objection, Your Honor. This is Louis Schneider. I have no objection. This is the first I've heard about this. I'm not happy about it. I agree we should take a breather and find out what really is going on here.
And here's the email that I sent to him notifying him of exactly what was going to happen today.
I haven't had an opportunity. I see that Judge Gibson signed the order. You're gonna have to refresh my memory. There's a difference between an open hearing and this.
If that's a question directed at me, Your Honor, I'm not familiar with the Supreme Court rule, so I'd have to look that up.
My big concern is that I don't mind open hearings where people come in and listen to what's going on and they're part of that process. It bothers me a great deal where the avowed purpose that's been stated by them is that they're going to put it on the internet for the world to see. You don't even have to show an interest. You just need to go on your internet and here it is. It's for the world to explore and to see, and it involves children, representations about children, where the avowed purpose is just to post it in general on the internet through their website. They have no interest in this case other than it's a case, and they admit that they. Do you have some policy over how you're going to handle a 432B case?
We've published it. It's under our internal operating procedures. All of that is published on our website. So we have IOPs, we have a white paper. The Supreme Court has allowed us to broadcast other types of cases. I understand this one's different, but when we reviewed the statutes, it said it was open unless somebody files some kind of motion to get this court to say otherwise. So the default is that it's open to the public, which then triggers all of the
They didn't know
standard
this is what you wanted to do. They might have filed the motion and they known that,
Okay.
that this would include people other than them.
When attorneys-
What do you want? What does the district attorney want? If you want to, I'll be glad to continue the hearing for a week to have you submit documentation on whether I should allow it in this case. I generally don't mind if review hearings are listened to, and I don't. But it's very obvious that a review hearing and review hearings tell the public what is going on. Closing review hearings generally protects, I believe, agencies more than people. I have a great deal of difficulty in just allowing the taping and placing of general information on a website on the internet for the world to see.
So I don't know if you know, but we do redact the information that 432B requires us to redact. So there's
Maybe at a
list-
hearing, if we show that that's your policy and that we have written proof of that, it might
That's-
make it better for us. I'm not
that's
sure I'm
all-
willing to take your representation
That's
as to
already,
what the rules are.
right, that's already published, and we have example videos where we already do that.
Well, once you record it, I don't know that you're necessarily bound by that. What is it you redact?
So there's a list, but off the top of my head, it's names of the parties, names of the child, social security numbers, locations like addresses. The purpose of these videos is educational, not so much informational. So the public doesn't need to know those details. It just goes to the actual process of what the hearing looks like.
When did you develop this sudden interest in, you've published
isn't
all
a
the other,
sudden
when did you
interest.
develop this sudden interest in 432B hearings?
We've been broadcasting all sorts of different types of cases, and this is something that goes through the history of our organization, which started in 2014, though we started publishing cases in 2019. We look for all different types of cases and we publish them to the profiles of the judges so that people can see the different types of cases and the different judges.
How long have you been doing this?
Since 2014 for statistical analysis.
This is the first time you've got around to a 432B case?
This is the first time. And
That's
that-
not what I'm saying. I'm simply saying, you're folks, I don't care if you want to watch a divorce case, come on down, we'll give you a few.
This is the point where I lost all respect for the judge and I realized he was lying to protect either CPS or the district attorney's office. The reason I know this is because divorce cases are inaccessible by law, and this judge, who's been on the bench since 1993, for sure knows this. There's a statute that expressly forces the judge to clear the courtroom in divorce actions. It is similar to a law that is in place for paternity actions, termination of parental rights actions, and adoptions. Basically, I think that he didn't know that we knew this and that he was trying to deceive us into thinking we could just leave this case alone and go cover divorce cases. As the law forbids that, it would be impossible. Ironically, this NRS 432B proceeding is the only proceeding the law actually does give us an opportunity to provide coverage of, aside from non-divorce child custody matters.
Whatever you decide, if you don't want us to provide coverage, we'll leave.
I'm gonna be quite honest with you, I was a proponent and am still a proponent of the community and people in general understanding what happens in 432B cases. I think it's very important. There was a statute that opened up these hearings for the benefit of those who wanted to find out certain things. To the degree that people had an interest and a curiosity, I don't mind. To the degree that it's broadcast world, that's not what I think the legislature I had in mind. The unfettered right for you to photograph and to publish the identity, this has certainly had me rethink that. And I have to tell you the honest truth, what bothers me is that there's no purpose to this other than idle curiosity. Is there an interest you have in this case particularly?
We publish all of the cases to educate the public. All of the cases are published.
Why did you choose this case?
Because this case continues from the Department 15 coverage that we are already
It's
doing.
what?
There's Department 15 coverage in this case. There's criminal proceedings, and this is just another part of the process.
You started covering the criminal case downtown and
We've
you
already
wanted...
covered the criminal case downtown. We've already published those videos. It's hard to explain to you what our coverage looks like if you haven't seen it. To you, it looks like we're just random people who came in to record and publish something without doing anything to it. If you actually see what it looks like, it might make more sense to you why we're doing what we're doing.
Judge Gibson signed the order. 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 What do you want to do?
I would ask for a week to respond, Your Honor.
I'm sorry?
I would ask to continue it for a week so that I may file a response.
No objection, Your Honor. This is Louis Schneider. I have no objection. This is the first I've heard about this. I'm not happy about it. I agree we should take a breather and find out what really is going on here.
Matter will be continued 1 week.
He was okay with people physically coming into the courtroom and be curious. This is basically underlining that they want to say they operate transparently without actually being transparent. The reason why is because if they make it as difficult as possible for people to get access, they know very few people will actually exercise that right. Not only is it incredibly time consuming to appear and sit in at one of these hearings, it's not even a real option anyway. The doors are locked, and I would wager that if 100 random citizens approached and tried to get in, all 100 of those citizens would be turned away and told it was a, quote, closed hearing, unquote. I would like to end this on a positive note. There are other family court judges who are trying to change things and introduce the public to their proceedings. Take family court judges Linda Marquis and Egan Walker, for example. The guardianship scandal, much like the CPS scandal, seriously damaged the public's confidence in the system. Those two judges should be commended for opening their doors to the public.
Hi, Nevada judges.
Hello.
That's not a whole bunch of Nevada judges.
Our Nevada judges.
I'm just kidding.
Our Nevada judges.
I'm giving it a hard time. All right, go ahead.
Finally, I explicitly authorize our Nevada judges to record and broadcast the hearing on January 26th, consistent with their pre-hearing request in this matter. I had issued an order in this case authorizing a so-called press appearance or press participation in this case, and I continue that authorization for the hearing on January 26th.
We also have family court judges Tamitha Schreiner and David Gibson. Even though we were unable to record this specific proceeding, I strongly believe Judge Gibson would have allowed it if he was able to take the bench today. I also don't want to single out Senior Judge Gerald Hardcastle. There have been other judges who refused to allow cameras in their courtroom, though they were significantly more respectful and they let us know way in advance so we didn't waste as much of our time. Finally, I want to point out that we choose cases like this because they're already very public anyway. In this situation, the parents are already being subjected to criminal proceedings and they're already in the newspaper. They're former Las Vegas Metropolitan Police officers. We anticipated the public, after watching the criminal proceedings in front of District Court Judge Joe Hardy, would have questions as to how these dependency proceedings work as well. And we wanted to provide that to the public to give that thorough, comprehensive coverage that we provide here.
And I really felt that the family court was a place that should be open to the press. At that time, it was sort of the dumping ground for morons and political hacks. And where are we going to put them? We can't put them in the civil court or the Supreme Court because press goes in there to report. So we have to put them in a place where nobody can see the morons that we're appointing to the court. It was frightening to see the mentality of people who were impacting on the lives of families and children.
The judges.
The judges. So I thought it was a great idea to have cameras in the courtroom when I became a family court judge.